Well, Mr Chairman, I'm a bit reluctant to interrupt the flow of quality contributions coming from my left, but at this point, because that's right, there is no risk of that. So at this point, I would just like to make a couple of introductory remarks, but I won't be taking a large number of calls during this committee stage because this bill and the process around it has been debated widely, both publicly and in this House and during the Select Committee process. But I do want to respond to a couple of points that have been made by members of the opposition. The first is that the most important component part of the purpose of this bill is to confirm and to guarantee access to justice for those who cannot afford to fund their own legal counsel at a time, particularly in the criminal area, where it's absolutely critical good quality representation is made available for them. Secondly, it is also important to note that although Dame Margaret Baisley's report did refer to some lawyers who were perhaps below par, there were also criticisms made and subsequently followed through by the government with respect to the performance of the Legal Services Agency. So it was a two-way street in that sense. Now, the efficiencies and, frankly, once professional services are billed and performed to a reasonable standard, those practitioners are entitled to have their fees paid and are paid in a timely and efficient manner. So we have seen some big changes on the agency side, as well as some of the changes that are going through this particular piece of legislation with respect to good quality representation. Now, Mr Parker touched upon one or two issues relating to perhaps the potential for some further reform in these areas. And he tellingly zoned in on one or two areas that perhaps the government could have a further look at. And I want to reassure my colleague in the opposition benches that work is well underway. And this will not be the last piece of work this House deals with in the legal aid area in my time. So it will be an interesting debate that we will continue. So the point about affordability for the state, which actually is the New Zealand taxpayer, is an important part of that continuing equation. So some of the issues that Mr Parker raised around, for example, multiple defendants and multiple legal aid lawyers and the like, many of those issues and the efficiencies with which the court system deals with those issues, because, of course, all of those defendants are entitled to have their matters heard in a timely way. That is an important component part of the Bill of Rights in this sense. Those matters are being dealt with largely under the criminal simplification and modernisation legislation, which, when it's put alongside the changes to the legal aid bill which is contained in this legislation, those smart members of the House will start to see a bit of a plan emerging here, and that is to say that incentives across the justice system are being changed and tweaked and, shall we say, retargeted to ensure that those most in need are getting those services. However, what it does mean is that the government will continue to look closely at the broader affordability of the legal aid system. Now, what I've said publicly is that on the current track of baseline expenditure to vote legal aid, if I can use it, describe it that bluntly, compared to the growth that's expected in this area off the back of current settings, that is not settings altered with the passage of this legislation, over the next 5-year period, we are looking at a gap between those two lines of about $405 million. Now, that gap has to be addressed, and some of the issues that Mr Parker raised at the margins to this bill, but nonetheless some that were raised, will be the focus of further consideration by the government in coming months. In fact, I'm hoping to make an announcement in that regard shortly. So we will see continuing tweaking of the incentives in the legal aid system to try and muster taxpayers' money in a way which focuses solely on the good of those who cannot afford representation of legal services of their own. But presently, the system is clearly not incentivised adequately enough to avoid the type of slowing process, the bogging down of matters, the multiple representation of issues which have to be paid for to be dealt with by way of Mr. Chairman, other processes in the court system, which the previous government, in fact, the Honourable Rick Barker, had enough foresight to persuade the then opposition Justice and Corrections spokesperson to support the removal of depositions. And I might just dwell on that in terms of the purposes of legal aid for just 1 second, because actually I was approached by a reasonably significant, not sure what the collective noun is for a group of lawyers, but a very, very senior group of criminal lawyers who told me that if I proceeded with my fountain pen on the parchment and we did away with depositions, that this would cause major problems for the system. That's why, as the former minister may recall, we agreed, 1, on a review, but 2, to remain in the legislation, an application to be made to the judge to hear oral submissions in the event that the matters were complex and worthy of such an application. Turns out that since the removal of depositions, those applications for oral evidence to be heard have occurred in 3% of matters that have been brought before the courts. So those that have said previously that if changes to the legal aid system, to the justice system, to the efficiency of the way that we drive the system to ensure timely and quality representation would undermine the fabric of the pistols at dawn mentality, which effectively is the adversarial system that we have adopted, that is not right. And this House must have the courage to drive through changes to make sure that we test those notions in the most vigorous way. And this piece of work is only a small part of a piece of broader reform, which I hope will do that.
I call Jacinda